I'll never forget the sound of metal click like a hand slamming down on something that used to move freely like a door shutting on the idea of coming home. A brand new padlock dangled from my gate and stuck across it was a notice emergency closure by order of the association. One gate, one click, and the entire valley felt suddenly smaller. My name is Daniel Price, and that gate sat on the only timber bridge that let our cabins cross the creek. The bridge my grandfather built with calloused hands and other neighbors who believed some things should stay open no matter what developers or committees decided later. We drove up that morning with propane and canned food and a truckload of lumber, small chores, normal weekend things, and the chain was wound tight, the padlock knew enough to sting in the sunlight. Mara, the HOA vice president, stood there in sunglasses even though the shade made them pointless. Clipboard in hand, smile, practiced and dangerous. "This crossing is closed for safety remediation," she said, like she'd practiced the line in a mirror until it sounded like law. Behind her, 3 board members knotted clipboards like shields. The sheriff arrived a few minutes after public safety brass on neighbors, gathering cell phones buzzing with missed shifts and medication pickups, and the kind of small panics that feel enormous when your only way out is locked. I kept my voice even. Shouting never solved anything my grandfather taught me, and pulled the leather folder from inside my jacket. Inside was a faded warranty deed from 1948, an old bridge permit stamped by a county engineer in 1951, a 1973 survey showing parcel 14B running right across the creek with my family name on it. Paper in that moment felt heavier than wood. The deed said what the deed always said: that bridge corridor belonged to my family. No HOA plat covered it. No recorded easement gave them a leg to stand on. The bridge was ours. They doubled down anyway. $500 a day in fines. Mara declared effective immediately, and the crowd felt the pressure like a clock starting to tick. People started shouting about jobs and kids and medicine, and I pressed the shutter on my phone like a metronome documenting the notice. The timestamp Mara's clipboard, the chain building a digital file as evidence because paper matters twice, once in the county clerk's office and once in the courtrooms where people who think shouting wins learn otherwise. Here's the thing most folks don't get until they're in the middle of it. An HOA's rulebook is strong only where the land record is strong. Covenants and restrictions, the CC and Rs that feel like commandments at the monthly meeting, don't magically rewrite deeds. They bind properties inside the recorded plat the developer dedicated, but step off that map, and the handbook is just a nicely printed suggestion. I'd grown up with that knowledge tucked between timber and tax records because my family had always kept the papers neat. We'd paid taxes on that narrow strip. We'd filed permits. The bridge had a permit, a blueprint in my grandfather's careful hand, and a chain of title that didn't skip a beat from his name to mine. So I spent the weekend in the basement like a man poring over an inheritance that smelled of cedar and smoke deed permit, the 1992 license my father had written to give neighbors permission to pass, and in a dusty manila sleeve the clause that would turn a padlock into a mistake. My father's license was permissive conditional, and it carried a rider if any third party tried to claim control or encumbrance. The license could be suspended, and all access would revert to the owner until the issue was cured. My father had been generous when he granted passage, careful when he wrote the words, and he had tucked a reverser into the margin like a safety catch. When Mara and the board stapled their notices together and called them emergency orders, they hadn't noticed that clause. By locking the gate and pretending jurisdiction, they'd triggered the reversion. Legally, they'd voided their own claim to passage. It's the sort of bureaucratic misstep that reads small on a clipboard but hits like a landmine in law. Try to seize control of what you don't own and you've given the owner a way to respond. I did what my father and grandfather would have done. I lined everything up neat and precise. I printed the county assessor map showing parcel 14B. I pulled tax rolls proving we paid separately. I scanned the 1951 permit with the engineer's stamp, and I put it all in a binder and took it to a property lawyer who speaks paper like a second language. James Callahan didn't raise his voice once. He read the documents like somebody reading a map to find the right place to stand. "We don't shout," he told me. "We notice." Then he told me how to use the paper. We sent certified letters, demand proof of jurisdiction, cure or quit, notify county officials. the kind of steps that put the other side on record and give law enforcement and the clerk a chance to step in where posturing and padlocks should not. We made sure every step was calm surgical. Lawyers taught me that confident volume gets headlines, but precise documents get court orders. If the board pushed the special assessment they were planning to force onto homeowners essentially to pay for a takeover of something that was never theirs, we'd be ready. They pushed anyway. Emails went out about structural hazards with no engineers seal emergency remediation initiatives and an emergency vote to raise funds. I watched neighbors forward messages with a mixture of anger and fear. Johnson's worried about their kids' meds. Miller's worried about missed shifts. Someone else whispered about a recent 911 delay, the HOA manufactured crisis, and dangled a bill over everyone's head. That's when I saw another clue, a mismatch in parcel numbers in their own paperwork, sloppy and telling, and when I dug through the county's recorded instruments, the gap was obvious. No easement, no dedication of that strip to the HOA, no acceptance filed with the county. We took it to the county inspector and the sheriff, because sometimes facts need to be read out loud in public to cut through the haze of authority. The inspector traced the lines and nodded. Parcel 14B recorded to the Price family since 1948. The sheriff told Mara and the board exactly what I'd been thinking. You don't settle property with chains and padlocks. If you think you have rights, take it to civil court. He warned that future padlocks might cross into criminal trespass. I remember Mara's face, a practiced calm peeling away to something uncertain the moment a person realizes their script doesn't match the record. The HOA tried to rally the room with a glossy binder and grainy photos, but they couldn't produce a recorded deed. Their lawyer produced the CC&R's 86 pages of rules about paint colors and trash cans, and the judge later in the courtroom didn't need more than a glance. Deeds control real property. Handbooks don't. The judge restored the status quo, no interference with Parcel 14B, and if the HOA had safety concerns, bring certified inspections and move through the court. He even hinted at damages and fees on the next setting. Paper had spoken. Once the court's order landed, the house of cards started to wobble. Neighbors demanded records under nonprofit law, and what came out made people angry and frightened. A line item for bridge control vendor services paid to a shell company with no license invoices that didn't check out. Someone had already tried to graft a revenue stream onto fear. The community moved from confusion to action. Petitions for recall requests, for audits, anyone with an ounce of accounting sense following the paper trail until it burned. The board opened settlement talks because at some point a fight that costs reputation, legal fees, and the trust of your neighbors becomes a bad investment. They rescinded the fines, agreed to pay my legal fees, issued an apology, and this mattered more than the checks. Recorded new emergency access protocols like the logbook I'd posted on the gate. We wrote safeguards into the public record so future boards couldn't simply invent authority. Paramedics and law enforcement would have guaranteed access, no padlocks allowed, and any regulation hitting land outside recorded common areas required documented legal interest first. We recorded that, made it public, and that turned a temporary victory into a more durable protection. I'll tell you something I didn't expect until the dust settled. The victory tasted quieter than I thought it would. There's satisfaction, sure. The bridge stayed open. People stopped missing work. The Johnson boy got his meds on schedule, but the real lesson crept up slow like tide after storm. Power is easy to pretend. Force can lock a gate. But paper endures. Documents recorded properly and kept honestly outlast posturing and personalities. My grandfather hammered planks together with neighbors because he wanted a passage for family and community. My father wrote a license because he trusted people but feared complacency. I filed and recorded because the work of stewardship is often paperwork. For emergencies, for morning commutes, and kids with backpacks and old men who still like to sit on the rail and watch the water. The bridge taught me that guarding what you love doesn't always mean swinging a hammer. Sometimes it means keeping the record straight and the rules honest. And yet, as I stood there after the settlement, walking the planks with the sun turning the creek into ribbons of gold, my phone buzzed. The county clerk had sent a terse message. Different association just filed something about your creek. Want to see it? Another HOA upstream already talking about standardizing control of crossings. The war over padlocks wasn't over. It had just moved upstream. So here's the question I'm leaving you with because it sat in my chest long after the judge's gavel. When a community hands power to committees with little oversight, who do we trust to use it wisely? The people who get elected for goodwill or the rules and records that outlast them? Tell me, have you ever been on the receiving end of a power grab disguised as safety? Drop your story or tell me what you think is the right balance between local control and legal record. I'd like to know, and if you've got a document, keep it tight. Paper is heavier than a padlock.